The debtor's prison of early colonial America may not be a thing of the past. In 1833, the practice of debtor's prison was outlawed in America by federal law. In Bearden v. Georgia, judges distinguished between debtors who are too poor to pay and those who have the financial ability but willfully refuse to do so.
Clients often come to us at South Carolina Legal Services because they are being harassed for past due payments on accounts with finance companies. By far, their biggest concern is their fear that they're going to go to jail if they can't pay. This film will explore their stories and the myth of a South Carolina debtor's prison.
South Carolina Legal Services brings you voices from some of our experienced attorneys as well as actual clients to speak on the issue of debt collection harassment. In Richland County Magistrate Courts alone, over 1,600 claim and delivery cases were filed in 2014. Many of these cases are filed on the same debt. These actions are typically against low-income citizens who use short-term loans when they are in financial need. Citizens then may get caught in a debt trap they cannot get out of without education about their rights or simply filing bankruptcy.
When clients first come into my office, most likely they're scared of what's going to happen, embarrassed because this is not something they've been through before, but also they don't know their rights, their legal rights. They don't know how to protect them, and they don't know how to enforce them.
Short-term loan companies traditionally use claim and delivery actions because they can get a lien on household goods. The lien enables them to threaten the debtor with picking up small household items. These threats allow the short-term loan companies to scare people into paying more money.
Well, I didn't realize how difficult it was going to be. The continuous calling, the coming to the house, uninvited, making kind of what you call threats if you don't pay, or you have to come in here and pay, or we're going to do this, or we're going to do that, or we're going to file legal papers, we're going to bring the police up, all kinds of problems.
So were you scared?
I was scared out of my mind. I had to get drapes, curtains for all my windows because they would just walk up unannounced.
Did they knock on the door?
Yes.
Did they yell at you?
Yeah, they would knock on the door. I had to get a curtain from my front door so they couldn't see in.
These companies even offer a refinance of the loan when the principal has been minimally paid down. If the individual cannot pay, they threaten a pickup order from the court. Most often, these individuals don't know their rights and don't realize they have the right to a jury trial before their property can be picked up.
Hey, it started when I first started getting checks in the mail, and I was really in debt with the electric bill and the power bill. And when I got this check, and they said all you had to do is on the paper, so all you had to do is cash the check and just come in and sign paperwork. And I said, well, let me call the company. And I called the company and said, yeah, just go ahead and just go ahead and cash the check, and then come in later. And I said, okay. And I didn't have no idea what the payments were going to be, but I just went on. I took care of the electric bill and the water bill, and I got some things that we desperately needed, and then I went in later and I signed the paperwork, and I just really didn't concept how much this was going to be or how much my payment was going to be. But that's how. I was very vulnerable at the time. I could not get any help from.
Debt collectors can use the court as their personal debt collection courthouse because in South Carolina, a company is allowed to use employees as attorneys in summary court.
Debtors are really at a disadvantage in court, both because they're pro se on their own and because they're up against the employee from the loan company who they see as someone who knows the law and who they trust to grant them that due process in court. However, those same employees that threaten them with legal action as a way to collect the debt, they themselves are regular employees, non-attorneys. They may be trained, but they're not trained in the law of debt collection and litigating like lawyers are. Instead, those employees of the loan companies use this legal action as a tool both to collect the debt from them, threaten them that they're going to sue, and at the same time intimidate the debtor in court.
When I went in to renew the loan, they had 20-inch TVs on here, black screen, Rolex watches, and I didn't have any of that stuff.
Oh, okay, okay. And when you didn't have that stuff and they kind of figured it out, were they mad, and did they try to use that against you?
Yes, they did. They threatened, said I could go to jail for 30 days. And
Wow. Did they? How often would they call you?
every day, 24 times a day.
Wow. Did they ever come to your house?
Yes, they came out to my house. They tried to get into my house, telling me they had a right to come in and check the property. And I told them I did not have this property, that they were not coming inside of my house at that time. I thought, well, I just got bankruptcy, so I didn't think I had any other way to go.
How did the case turn out for you, and was it a good idea for you to get a lawyer? Was it helpful?
It was a great idea for me to get a lawyer, because if you don't know something, it's best to ask.
Loan companies have gone so far as to threaten clients into either obtaining another loan or humiliating clients by reaching out to their friends and family members.
I know I had given references, and it was my understanding that when a reference was given, it was to verify your location and that indeed the person knew you. And I have had my friends calling me saying that numerous times these people have called incessantly for months at a time. The finance companies for months at a time have called.
So are you saying that the finance company would call your friends that you put down on the loan just as a reference?
Yes.
Trying to talk about your debt that they're collecting?
To get me to pay the debt.
Our summary court system has become just another debt collection device that creditors use to harass debtors. In the minds of debtors, debt collectors using the threat of a court order backs up the use of illegal tactics and threats.